controversial. What about corporations? You got a corporate client. The comment says that the client includes the person who oversees you or you receive directions from, and that would be true if you're a government lawyer or a lawyer involved in corporate representation. Here is the world's best sex with clients court decision. It's out of Wisconsin, 2007 in Glemo. In Glemo, what happened there is the lawyer has sex not with the client but with the client's girlfriend while the client is having sex with the girlfriend. Okay, so it's a three-way. And the Supreme Court of Wisconsin says, well, he's not having sex with the client. He's having sex in the room with the client, but it's not sex with the client. So it shows you how bizarre sometimes these interpretations get. But anyway, you've got a proposed sex with clients rule. Read it closely. Now let's get into conflicts of interest. Because conflicts of interest are the heart of the controversy that we hear the most about. And we have Rule 1.06, 1.07, 1.09 we'll focus on. As you know, we currently have Rule 1.06, which is the general conflict of interest rule, current conflict of interest. Then we currently have Rule 1.07. In Texas, it is now an intermediary rule. It's going to be totally changed, and that's a lot of the attention is there. And then, as Eamon mentioned, 1.09, the former client conflict rule. Proposed Rule 1.06 changes from the current rule, and it adopts definitions that are pretty close to the ABA model rule, this particular one that does. But then it does this. Rule 1.06 and 1.07 expressly cross-incorporate one another. That means that any time you're going to represent two or more clients, you have to satisfy both Rule 106 and 107. No other state has a dual general conflict of interest rule structure, and as you'll see, it has some issues associated with it. But that's one of the touchstones of the controversy. 106, 107, radical change to our conflicts rules system. Okay, 106, what's a conflict of interest? The rule defines it. Now, the conflict of interest definition is representation of one will be directly adverse to another client, or there's a significant risk that the client's representation will be limited by responsibilities to a third party or another client or the lawyer's own interest. So that's relatively standard stuff.
Let me just say one thing, that what's important about that change, essentially those two standards are the ABA standard, but what the existing Texas disciplinary rule provides that for directly adverse, they have to be substantially related and directly adverse. And what that meant is that you could sue an existing client, or at least it eliminates some of the problems of adversity with respect to existing clients. And these revised rules on that provision, they've taken out the substantial related dual aspect to directly adverse. So it's going to be just a directly adverse standard now, which makes it more direct, it tightens it up. That's what it does.
Yeah, it's a stricter rule. The proposal is stricter than what we have in Texas. Texas has been unusual, though, to have substantial relationship in 106 as opposed to 109 and 415. But anyway, that will change under this structure. Okay. When can you represent clients in the face of a conflict of interest? The rule says that you may do so if you reasonably believe you may provide competent and diligent representation, and if the representation complies with Rule 107, there's our cross-incorporation, and if the client gives informed consent confirmed in writing. All right? Confirmed in writing, informed consent. And so we have to go back to the definitions for that. The definitions say that you obtain informed consent by explaining the material risks and the reasonably available alternative. Risks, alternatives. The comment to the rule goes on and fleshes that out a little further, or adds some concepts, and says you've got to explain all the facts leading to the present situation of the client. You have to explain the advantages, disadvantages, alternatives, and you may need to tell the client to seek the advice of another lawyer. That may not be substantively that far off from what we have under current Rule 106C2, but the wording is very different. Then you have to have confirmed in writing. What does that mean? You have to have a written conflict consent from now on. We didn't have that requirement in Texas. Confirmed in writing, defined by, again, the definitional rule, which is 1.00K. I'm sorry, the 1.0F confirmed in writing. And it says it's provided by the person, so your client provides it or you provide the confirmation of the consent, the informed consent. Comment 3 says the purpose is to impress upon the person the seriousness of the decision and help avoid disputes or ambiguities. And comment 15 says that you need not provide it in writing. It's not required, but you should consider that, and you have to have confirmation in writing. And questions come up, what does that mean? Can I send my clients an email that says this is to confirm that you have given informed consent to the conflicted representation? Does that suffice? Don't know.
Chuck, let me just add right here that for informed consent, the rule provides that the standard is after the lawyer has explained in a manner that a reasonable lawyer would believe sufficient for the client to understand, which is completely opposite from what the courts have held, that you have to display it in a manner that a client can reasonably understand. Not whether the lawyer can understand it, but whether a person that doesn't have a law degree can understand it. That was one of the additions that they've made in the definition.
And that is, again, the opposite of the ABA approach, which says you're getting informed consent, basically. You're obtaining an informed consent of the client. You got to look at it from the client's perspective. But it's different. Okay, imputed disqualification. We have another definition that's critically important. Look at the definition of affiliated. We'll turn to that shortly, but imputed disqualification applies to affiliated lawyers who know or reasonably should know of the prohibition. And the simplest case of an affiliated lawyer is one of your law partners or shareholders or associates in the law firm. And the question critics, I guess from a public interest perspective, have said, well, how could you not know? Or when should you not know that your partner has a disqualifying conflict? And this concept of scienter defense runs through the rules. And some people think that's good, it'll make things easier, and some people think, no, we're going to end up in a lot of grievances or disqualification hearings where what we're really trying is reasonableness. And we'll see. Rule 1.06, comment 9, which some solo practitioners did not like, singles out large firms and says, well, large firms, especially with offices in different cities, would be vulnerable, particularly vulnerable, to an unwitting and innocent violation absent this signed requirement. I think Amy and I both think that's probably not true. I mean, every large law firm we've been with and everyone we've worked with has computerized conflicts checking. And back when I was with Jones Day, we'd get a giant conflicts check documents reviewed before we took any new client. And I don't think anyone should depend upon that as being much solace for a large firm. I think if you've got a conflict and you don't notice it, you're having trouble.
Yes.
All right. This is the favorite one, 107. This is multiple clients. This is no longer an intermediary rule. The ABA abolished the intermediary rule, concluded it didn't work too well. And so if you look in the ABA model rules from 2002 on, there's a blank where they used to have the intermediary rule. But we still have it. We won't now. This is another conflicts rule. It applies any time you have multiple representation in any matter. Lawsuit, transactional, administrative, this rule applies. And it applies in addition to Rule 106.
Let me just say something in terms of contrast of that, just to expand on that. In the intermediary rule, the ethics opinions in Texas had interpreted the intermediary rule to exclude litigation. So joint plaintiffs or joint defendants were not covered by the intermediary rule. They are covered here. So that's the difference dramatically.
Yeah, it's not really the intermediary rule anyway. I mean, the standards are completely different than the intermediary rule. And so the questions come up, why have it? What it ends up with really has two parts, because you do have to look at the comments, very important comments on this one. But in the basic rule, you end up with Miranda warnings. So anytime you're going to represent two or more clients, you're going to have to give them Miranda warnings. Now, why are you doing that? You remember back in Rule 106, to get informed consent, you've got to explain all the material risks with a reasonably available alternative. Well, why are you giving additional warnings in 107? If it's a material risk, you already had to explain it in 106. If it's not a material risk, why do you have to explain it? That's been a central point of criticism of this rule. What the heck is it, and why do we have it, and why do we need to be the only state in the country, in the nation that has it? Required disclosures, and these are the so-called Miranda warnings, before you represent two or more clients. Number one, pretty simple, you must act impartially. I must act impartially. What does that add? Not sure, but that's one of the warnings you have to give. Number two, I cannot advocate for one client over another, and therefore, each client must be willing to make independent decisions without the lawyer's advice, to resolve issues among the clients, plural, concerning the matter. So I've got to tell all my clients before we start that I can't advocate for one of you against the other, settlement issues, that kind of thing. And so you have to be willing to make independent decisions without my advice. The criticism that's come up with that is, take your classic settlement situation. The defendant offers two plaintiffs $100,000 to settle, or plaintiff offers two defendants $100,000 to settle, and it's got to be divided up. Obviously, the lawyer cannot advocate for one client against the other, but what if the clients ask for advice? The clients say, well, just tell me, tell us, you can't advocate for one of us over the other. What would a jury be asked? What are the controlling issues of law that a court would look at if we went to trial and there would be a final determination? Just give us that advice. Well, no, I can't, because you have to be willing to make independent decisions without my advice. That's the confusion or the criticism of this Miranda warning, is it's not really accurate with the way we do act or should act towards clients. That's gotten a lot of pushback.
Let me just say that as a corporate lawyer, I've been doing joint representations in forming entities. It's very unclear what I can really say to it. I've always been, obviously, not an advocate for one or the other, but this places some restrictions in terms of what I can say. When you ask about, let's talk about how we're going to, is it better for us to have a formula for resolving the purchase price of stock? How have these been interpreted before? Or should we have a value? Should we have an appraiser? This sort of thing. It's questionable what I really can say under that circumstance anymore.
The third Miranda warning is, that's my requirement of withdrawal. You must confirm that you've given these warnings in writing, again, and confirm the informed consent. Comment 11 says that you should consider making these in writing. So if we adopt these rules, you're going to need to have a new set of forms dealing with conflicts involved, that's for sure. Comment 12 to the rule says this. It says, well, here's some other disclosures you should consider making. The effect of co-representation on confidentiality and disclosure duties, and that joint representation may be more expensive. So it may be more expensive for you to represent two clients at once than for them each to have separate lawyers. Kind of hard to figure out when that applies, but anyway, that may be an additional one you may need to make. Okay.